file controverting affidavit. Her name is Dickinson, not with an N, but Dickinson. And she has 22 years of real world hands-on experience in the art of medical billing and coding. She also includes, she also has used nationwide databases such as Fair Health Inc. or I think they said it was called, let me find it. I have it. Give me a second. It's on page 3 of NRA Allstate, which I provided to the court in the binder. She used a company database. She then uses a company called Connect for Healthcare, similar to Fair Health Inc. Okay. So what she does is she uses her 22 years of experience in the art of medical billing as a medical nurse and coder, as well as her online experience of actually going on and using a database like Connect for Healthcare or Fair Health Inc. to find what the median charges were for each CPT code in the geo zip code area on the date in which services were rendered, similar to the language that we have in Roundtree as to the time and place services were rendered. On page 8, the court, after a lot of arguing, the plaintiff in this case said that no, Dickinson's not qualified because she's not a medical doctor. Only a chiro can controvert another chiro, or only a doctor, a radiologist can only do another radiologist. Now that may still apply when it comes to Daubert as to the causation. In other words, the billing is one issue. Were the charges reasonable in the Dallas-Fort Worth area? And then 2, we're not here today because we're not making a Daubert challenge. We're just filing a motion to strike the controverting affidavit. But if we were here, then we'd be talking about their qualification to talk about the causation in this accident. Well, he may have had these charges, but they weren't reasonable because when I look at this, he should have cut the date off 7 days in, 10 days in. And so it's not causally related. That's not what we're here to talk about today. But in NRA Allstate, which changes the playing field for controverting affidavits, the plaintiff argued, or Allstate argued that, or excuse me, the plaintiff argued that Dickinson was not qualified because she wasn't a doctor or other medical provider in the same field of medicine, and they disagreed. They cited to Gunn, where a subrogation adjuster who had knowledge of medical billing and databases was able to testify. So what they said here, that Dickinson also is similarly qualified to talk about these charges that's set forth in her affidavit because she has her education and over 2 decades of experience as a registered nurse. That's what I like to call two decades of real world hands-on experience in the art of medical billing, including a dozen years as a medical biller and coder. And here's the important part, Your Honor, and experience using nationwide databases that compiles the amount charges for the same or similar services in the same geo zip code area, Your Honor. Now, in this matter, Dr. Clifford has no real world hands-on experience in the art of medical billing. He admits in his deposition, over the past 20 years, he has never sent out a medical bill in his practice for collection. Now, he knows what the code is. He writes in CPT code 9213, then he hands it to the billing office and they do the rest. Okay? I'm not saying he doesn't know what a CPT code is, but I can go onto Medicare's website and look up a CPT code for a manual manipulation. That doesn't make me an expert in the art of medical billing. Okay? In Clifford's deposition, and this isn't in my brief, Your Honor. This is me working last night, rereading NRA Allstate 3 times. In his deposition, Your Honor, on page, get this in the middle here, page 31 and 32. Okay. I asked him, what databases are you using here? I'm sorry, we go up here to 31. You said you use databases. Yeah, well, I include Medicare. I mentioned the major plans, but he says he doesn't use. I don't see any databases in your chiropractic manipulation. Bear with me.
I think I get what you're arguing is that he's not
Hold on,
really
32. It's on page 32. Hold on. I'm sorry.
okay.
Okay. So I just looked at these databases. Did you look at any databases to create this report? Oh, I just didn't have to because I'm already aware of the allowable rates. Okay, so he says he pretty much, I don't need to look at databases. And then on page 48, he says, he controverts himself, Your Honor. He says, on page 49, what databases do you use to find out the cost of the billing zip codes in Dallas Geo zip code? Like I said, I didn't have to look because I already know. Objection non-responsive. He says he already knows, but he said he didn't look at them. Later, early in his deposition on page 32, he said he looks at Medicare and Medicaid. Where's 31? But and Aetna. I looked at Medicare, Medicaid. I also mentioned major health insurance companies. And the bottom line here, oh, where's on page 50? On page 50, he says he doesn't have them memorized. Where is it? 49. Okay. As I mentioned, I did not look up these databases. I reviewed them within the past week. He says, but I can't have everything memorized. So on one end, he says he looks at the database, he knows all the databases by heart. And then on the other end, he says, I don't have them memorized. Essentially what he's done, Your Honor, is that he uses his own medical practice to determine what he believes is a fair medical billing in this area. But he doesn't comport with the new standard in Mri Allstate. He's never taught a class. He's never taken a class. He's never written a paper. He's never done, he has literally no experience in the art of medical billing for even for chiropractic billing, other than his own practice. It's a subjective, I'm a doctor, therefore I am. But Mri Allstate says that is not proper. It's more than just being a doctor. You have to have that real world hands-on experience. And I know I don't have to I don't want to reinvent the wheel here, Your Honor, because I know you already know this. Okay. I'm going to page 8 here on the very top. It says here, the controverting affidavit must be made by a person who's qualified with knowledge, skill, experience, training, or other expertise. He doesn't have this expertise. He may have been qualified prior to Mri Allstate, but Allstate decided to throw the dice at the Supreme Court, and now there's a new standard. They need to have real-world hands-on experience in the art of medical billing and implement fair databases into their methodology. Not someone else using, and say, for example, this isn't the case here, but let's say this is a med cost contained one. Well, just because he has an affidavit written by somebody else doesn't mean he has the expertise. I'm challenging Clifford's expertise as a medical billing expert because he has no real world hands-on experience. He's, like I said,
Mr. Legge, does he challenge reasonableness and necessity or just reasonable?
Yes. Here's another problem with his affidavit. Let me pull his affidavit up, Your Honor. Let me get out of this. I have to be able to, sorry. In his controverting affidavit, where is it? He opines, let me get to the bottom here. Here we go. He states that when he goes through everything, he gives us what the prices would be, okay? But then he goes into causation. Only 9 manipulations totaling $450 are reasonable. He cuts it off in his opinion. He says that they should, he essentially says of the 23 chiropractic manipulations that were performed, only 9 were reasonable. Moreover, he says that the MRI, he also controverts the MRI. Somehow he's a radiologist when he admits he's not in his deposition. And he says it wasn't medically necessary, therefore it's not reasonable, therefore it should be stricken. He doesn't even give a price as to what an MRI should be. He just says the MRI is not reasonable. It's not medically necessary. Just like he says back up here that the treatment is not medically necessary. I'll find you where it says here. It's easier for me to look at my affidavit when I went through his affidavit. He only says that 7 charges, 9, here it is, 9 chiro manipulations for $50 each. But when you look at the medical billing for my client, which I'll pull up now, when you count the chiropractic manipulations starting here on 627, there are 1, 2, 3, 4, 5, 6, 7, 8, 9. So he stops right here, Your Honor, with chiropractic manipulations, but there are more chiropractic manipulations, and he doesn't include that into his opinions on page 6 of his controverting affidavit, because he only added in the 9 chiropractic manipulations. So he's incorporating causation into his controverting affidavit. What he should have done is said the 9 chiropractic, he should have said that the chiropractic manipulations should have been billed at $50. There's 23 chiropractic manipulations, and here's the bill it should have been. When he decided to incorporate causation into his controverting affidavit, it becomes defective because it doesn't comport with the law. The law requires him just to talk about the charges, not the necessity of the treatment. That's what his retained expert report would be for Daubert, and to say that this isn't related. Number one, the charges are too high, and here's all of the charges, 23 manipulations. And Your Honor, when we go into the jury and he starts testifying as a Daubert expert, because this isn't a Daubert challenge, this is just a controverting affidavit challenge, Your Honor. And what he's done is he's improperly incorporated causation into this affidavit. Therefore, the entire affidavit should be stricken as a matter of law. I'll pass at this juncture.
Response.
Okay. So I'll start off with the causation argument. In this case, I understand the line between causation and medical necessity is always, it's not a fine line, but in this case, he's simply not arguing causation here. He's saying that the chiropractor who has the same qualifications, just about same experience that Dr. Clifford has with his practice, misdiagnosed plaintiff and gave plaintiff too many treatments, stated that plaintiff's treatment plan was going to take 23 visits, when in fact, plaintiff's injuries should have only been resolved within 9 visits, 9 or 10 visits. Now that's arguing whether or not the treatment was medically necessary. That's not arguing causation. If he was arguing causation, he would have said, these are not the types of injuries that would be produced by this accident. Now that would be outside the scope of what Dr. Clifford is able to do, because he's not a biomechanical expert. He's not able to testify on the forces caused by an automobile accident. And he's not able to testify the forces that the human body would have sustained in that automobile accident. Here, he's just arguing that the plaintiff was misdiagnosed. Plaintiff's diagnostic treatment was not thorough enough, was not what was normally recognized in the chiropractic field. And so as a result, there were mistakes made by plaintiff's chiropractor or unnecessary treatment rendered. That's completely within what the bounds of a counter affidavit is allowed to argue. And not to mention,
and how do you say your name, sir? Mr.
Kuritzkis, Your Honor.
Kuritzkis. Mr. Kuritzkis, so do you agree with Mr. Leegee that in order to challenge reasonableness, you need to have somebody like a billing clerk, like it says in Mri Allstate, and
I disagree, Your Honor.
And hear me out. In challenge necessity, you would need some kind of medical provider.
I disagree, Your Honor, because Mri Allstate it didn't deal with the necessity of treatment. It dealt with the reasonableness of charges. And so the court didn't really dive into that argument here. The person who was reviewing the charges in there She was reviewing the billing, and I don't really see much about whether or not the treatment rendered was necessary in that case law.
I probably didn't ask that very artfully. Let me try again. So Mr. Leegie's argument is to challenge reasonableness under NRA Allstate, that you would have to have somebody with experience with analyzing medical bills, treatment. I will tell you, before NRA Allstate, I would systematically strike every one of these billing clerks in pretty much every situation. NRA Allstate says that's not appropriate. And there's language that Mr. Leegee quotes to. So do you agree that in any case where there's simply challenging reasonableness, you would have to have somebody with that type of expertise, or can a doctor or chiropractor still do that type of analysis? And if so, how do you analyze in that? And how do you make that argument in light of NRA Allstate?
I would argue, Your Honor, that any medical professional would be qualified, or who is qualified at their position, would be able to analyze the amount that one of their peers has charged for a service.
How do you make that argument in light of NRA Allstate? What
Well,
language
because
in NRA Allstate?
You have to look towards the doctor's qualifications, Your Honor. And here we have Dr. Clifford. He's owned his own chiropractic clinic. Let me get his.
And are there any cases that cite to NRA Allstate yet that have? I know it's a fairly new case, but that talk about whether or not a medical provider, a medical doctor, or chiropractor can counter on reasonableness. Is there any cases that address that issue yet?
I'm unaware of any cases that flush out NRA Allstate to that extent, Your Honor. But with respect to why Dr. Clifford would be, available to opine, or should be allowed to opine on these the charges, he's owned his own clinic for the better part of 2 decades, Your Honor. He, as part of being the owner of a clinic, you need to set your own prices. You need to understand how the reimbursement will work.
Doesn't NRA Allstate though specifically overrule Turner v. Peril?
It overrules Turner v. Peril. In what sense, Your Honor?
Well, in Turner v. Peril, which I used to rely on regularly, basically said in order to counter, the way I always understood it to mean is when in order to counter, for example, you had to do apples to apples, oranges to oranges. So in order to counter a chiropractor, you'd have to have a chiropractor counter. In order to counter an orthopedic surgeon, you'd have to have an orthopedic surgeon. You couldn't have these shotgun approaches like it did in Turner v. Peril. In this case, with that being overturned, does that mean a chiropractor can't counter another chiropractor, or how do you analyze that issue?
Your Honor, the way that I read NRA Allstate, I don't see any language to the effect that a chiropractor would not be able to controvert another chiropractor. My understanding from NRA Allstate is that it's just a two-question approach, whether or not the expert was qualified and whether or not they gave reasonable notice as to what they're going to controvert, and that at the if the plaintiff's counsel believes that the methodology was lacking, or that the foundation wasn't there for what they were saying in their counter affidavit, then that would be more of a Daubert challenge, or that would be something to try to impress upon the jury at trial.
I do agree with you on that. I do agree with you on that part. I mean, I think one of the big problems in NRA Allstate, and I've always been kind of careful not to do this, and I'm not criticizing the trial judge at all in that case, but the trial judge also struck the expert for Daubert, and that's not really what a counter affidavit, striking a counter affidavit does. It doesn't necessarily mean that the expert can't testify as to at trial. It just means that they can't file the counter affidavit. But so I agree with you to the extent that that there's 2 different analyses here. One is whether or not to strike the counter affidavit, and the second one is whether or not to strike them under Daubert. And those again are two different analysis according to the Supreme Courts. And I think they're probably right on that point. Anyway, so we kind of got a little bit diverted here. So Mr. Leegee, I think his best argument is here that he's challenging necessity, not causation, in saying that only 9 chiropractic visits are necessary as opposed to caused by. So how do you kind of counter that argument?
First and foremost, I do want to counter that, but just to let you know, under Mri Allstate on page 9, in contrast to reasonableness we recognize in Gunn, medical providers are best to position to determine what kind of treatment or procedures resulting expenses are necessary. So medical providers ideally be the ones who testify to the necessity of medical expenses, or put it differently, whether a particular course of treatment was necessary under relevant standard. That's like the Daubert. But even as to necessity, we state that the ideal I can't even pronounce that word, Your Honor. Paradigm does not reflect today's complex health care system. And the reality of our healthcare system does not require the testimony of the necessity of the medical expenses to be limited to medical providers. Now, I will say that a medical provider could be qualified to render these opinions had they have that experience. But when they pawn it off to a third-party administrator, Your Honor, like Clifford has done over the past 20 years, he's never created a medical bill. Here we go. Is this safe to say in the last 20 years you've never created a medical bill yourself and sent it out to an insurance company for collections, used third-party administrators in the last 20 years? Oh, it's been about 20 years. Now, had he been doing his own medical billing, we'd have a different story there, okay? I wanted to get that off my chest. Now, talking about whether or not the medical necessity, that's the same way of saying that you shouldn't have had that billing period. Can you agree with me on that, Your Honor? He's saying it's not medically necessary because the doctor made some kind of mistake. That's the same thing as saying, Your Honor, well, he had a pre-existing condition, and we believe that after 9 treatments, that anything else he had was not related to the car accident in of itself. But a controverting affidavit isn't here to talk about how many treatments you should or should not have. Okay? It talks about the reasonableness of the billing. That's what I'm saying. He doesn't address the reasonableness of the billing for all 23 charges. Okay? So when he steps over that line and says, well, they should only had 7 charges or 9 charges.
Mr. Leegee, what I'm trying to get at is so there's 2 issues here, I think, on necessity. One is, can he counter on the MRI? I would say at this point, no. So the MRI, he doesn't counter as to reasonableness. He hasn't countered as to necessity. The MRI is fine. I'm going to strike the counter affidavit as to that. Because I don't think he's qualified to testify about that. So the second issue is,
Your Honor, if I may.
Let me finish. The second issue is, can he counter as to necessity of those additional treatments? So the 9 was there 23 treatments, and he said there should only be 9. That's where I'm kind of struggling, is why can't he testify as to that, or why can't he counter as to that?
Okay, and let me go to his affidavit and let's look at it. What he says here, the chiropractic billing lacks supporting documentation. The standards are not, he's not saying he made a mistake. He's not saying that there was some kind of malpractice. He's saying that he didn't like the way the billing looked. And because he didn't like the way the billing looks, that the charges aren't reasonable. Okay, he didn't say that the doctor violated some standard or policy, therefore rendering the treatment unnecessary due to medical malpractice. He just says that the documents don't have the right billing according to him, and therefore he deems them not necessary. That's different than the argument that the opposing counsel just provided to this court in open court, saying that the doctor made a mistake and committed some form of malpractice. Okay? So when you go in here, also, that's it. I mean, it's not a malpractice issue. It wasn't that they weren't reasonable, necessary. He just says the billing doesn't support the proper documentation in his opinion. Therefore, it's not necessary. That's my response, Your Honor. And as such, he doesn't have anything in his contradicting affidavit or his deposition saying that the doctor, we have to cut off these chiropractic manipulations at 9 treatments as opposed to 23, because this doctor, this chiropractor, they're not medically necessary because this doctor made a mistake. As James, I can't pronounce his last name, but as opposing counsel said, he made a mistake and it should have been cut off at 9. He didn't make a medical mistake. This doctor, in his subjective opinion, believes that the chiropractic bill lacks some form of documentation. And furthermore,
okay, let me hear back.
That's it, Your Honor.
Mr. Kurtzer.
So
what is your argument as to that about the where in the report does it say why 9 is appropriate and 23 isn't?
If I may just pull up the report, Your Honor. On page 3 of the counter affidavit, it states that there are no objective findings noted to the neck or the back. Musculoskeletal exam showed normal range of motion. Left knee exam exhibited bony tenderness, but he exhibited a normal range of motion. So you have all of, and I could go on for another half page of what Dr. Clifford disagreed with, but you have what Dr. Clifford states, for the injuries that were claimed, Dr. Clifford states what should have been the symptoms, and he compares them to what are the symptoms. And that's in his experience in his 25 plus years as a chiropractor, and what he is and how he would diagnose the patient and what kind of treatment he would recommend for the symptoms that plaintiff was experiencing according to plaintiff's chiropractor. What it boils down to, Your Honor, is there's a difference in opinion in what Dr. Clifford believes is a reasonable amount of treatment for plaintiff and what plaintiff's providers believe is a reasonable amount of treatment. And that is exactly the kind of, there's no argument that Dr. Clifford is not a qualified chiropractor. And that is exactly the sort of thing that a jury is going to have to decide at trial, is how many visits were necessary for these for the injuries sustained. Dr. Clifford cites, he shows his work essentially by saying this is why, because these symptoms were lacking and these were the symptoms that were there. And so further treatments were not based on the reevaluations that were done throughout the chiropractic process. Further treatments were not necessary. And so, going back to plaintiff's argument about, well, why is there 9 instead of 23 treatments on there? Well, Dr. Clifford simply states that the amount should be 0 for treatments 10 through 23 because they were not necessary. If a jury were to determine that they were necessary, they could use what Dr. Clifford states as a reasonable charge for the amounts that the treatment that was received. And then they can deduce what plaintiff should have been charged, or they can go with plaintiffs, their own experts, evaluation of what should have been charged. But the bottom line is the jury is going to have to at trial wrestle with the difference between what plaintiff's chiropractor recommended and what Dr. Clifford recommends are reasonable numbers of treatments for the injuries sustained. And that is what he's doing here. And briefly, Your Honor, I'd like to address the MRI issue. What Dr. Clifford is,
I've already ruled on that, so you don't need to address it. Mr. Lee,
brief rebuttal, Your Honor.
Brief rebuttal.
Okay, very brief. Well, in this instance, if you find that his logic is sound, then I have to go this route. He has no peer-reviewed articles or any type of that are generally accepted in the chiropractic community to support his subjective opinion that none of this is related. If he believes that having only 9 treatments is something that is not medically necessary, he has no articles to support this. This is completely subjective. It's that Dixpo, however you pronounce it. Just because I say it, it makes it so. If he believes that the treatment's not reasonable, it's not necessary, and that 9 is the cutoff, then they should have provided some articles to support those opinions. They should have had some peer-reviewed articles by the chiropractic community that agree that in this instance, that this isn't necessary treatment. And in this instance, he should have had some type of articles to support the argument, hold on, that I believe he brought it up here, that none of the exercises were necessary. He has nothing to support these subjective opinions, and he just says it and makes it so. If that is the case, and you believe that necessity can be argued, they need to be able to support it as an expert. You just can't say it and make it so. And they have provided no articles to support any of these opinions, Your Honor. None.
Your Honor, we're getting into a Daubert challenge. The only two questions, according to Allstate at this juncture, are whether or not reasonable notice was provided, which it was. Dr. Clifford stated what his opinion, what his conclusion was, and how he found out about that. And Dr. Clifford's qualifications as a chiropractor. Citing articles, that's exactly one of the 702 factors, and that is precisely what will be brought up during a Daubert challenge, which is not what is plaintiff has styled their motion as. And so it's irrelevant whether or not Dr. Clifford, what his methodology or what he's, how that he hasn't cited anything to arrive at his conclusion. All we need here is him to be a qualified chiropractor, which there's no argument that he's not. And he has to give notice, and he has to provide, a reasonable basis to arrive at his conclusions, which he does. He disagrees with the diagnosis of plaintiff's chiropractor based on the symptoms which were listed by plaintiff's chiropractor in the medical records.
And this does sound like a Daubert challenge, Mr. Leegee.
I understand that. I don't even know if he's even listed this doctor as expert. He may just only have him as a controverting affidavit doctor. So hold on one second. If he's listed him as a Daubert, if he's listed him as a retained expert, oh, he has. Oh, wait, no, he listed him as a person with knowledge. And it's okay, Your Honor, I agree. What I will do then is I will file a Daubert challenge. We'll revisit his expertise and qualifications under Daubert. Since he's not only a controverting expert doctor, he's also now a Daubert expert as well. What I like to do is I like to reserve. I'm going to let the court and James know I'll be filing a Daubert challenge as to his opinions in this report, because they're not supported under Daubert.
How big a case is this? Is this a case where we could just do dueling affidavits? Can you guys agree to that, or do we really need to go through all?
I'll bring my doctor live, but I'm going to go ahead and I'll file a Daubert challenge.
Your Honor, this is a minimum policy case. I believe that we would be able to do dueling affidavits if opposing counsel is agreeable to it.
He doesn't seem to want to do that, Mr. Leegee.
Well, if you've already stricken the MRI, I would be willing to consider dueling affidavits regarding, as long as the MRI is not part of the deal.
Yeah. Well, what if we did this? This is what I would suggest. This is not a ruling, just a suggestion, is that you do dueling affidavits on the issue of necessity as to the chiropractic bills, and then leave everything else out. Reasonableness is not going to be challenged, and the MRI bill is not going to be challenged. And then just do, because I do think that it's a very close call as to the necessity argument, and do dueling affidavits just as to necessity as to the chiropractor. Mr. Leegee, what about that?
Well, that's something I'd like to consider. I believe.
Otherwise, I have to make a ruling today.
Well, actually, I can't. I have to look and see what his affidavit says versus our I think our medical bills. Don't get me. I don't want to start lying here, Your Honor. We have a medical bill, chiropractic billing of $7,300. His counter affidavit has us at.
But just as to the issue of necessity, not as the issue of reasonableness. So it would just counter to say that it should be 9 instead of 23. And Mr. Leegee, I'll quote one of my favorite mediators: pigs get fat, hogs get slaughtered here.
Dueling affidavits. Does that mean that I'm agreeing that Dr. Clifford doesn't have to come and testify? He's a retained expert. I can still bring him in under causation under his designation. You're just talking about the medical.
That really defeats the whole purpose of that. If you're going to do that, then let me just deny them. motion to strike, and then you just go ahead and let him testify at trial.
I mean, I could go ahead and do a Daubert challenge as to his opinions, and if those get struck, then obviously.
Then
that
you
would
still have
change
to
it.
call your doctor live.
Right. I'll do dueling affidavits
On that one point.
on the
Mr.
one point
Kurt-
for the chiropractor only, as long as we're ruling that the MRI comes in.
MRI comes in, chiropractics is just a challenge, only as the necessity.
Right, and we can argue before the jury what is and what is not necessary.
Correct. Mr. Kurtzer, do you agree?
So yeah, it would be, so the only issue, let me just make sure I understand, Your Honor, is that, whether or not it should have been 9 or 23 visits. So Dr. Clifford's opinion as to the prices of medical treatment, that would be struck on this ruling.
No, it's not a ruling, it's an agreement.
Okay.
I'm not making that ruling. If you want me to make a ruling, I'll make a ruling, but if you can
Yeah,
agree.
we can agree for just the 9 versus 23 argument.
But
Okay.
James, to be clear, though, he's saying that we're going to be able to put our affidavit for $7,300 out. You're going to have your affidavit out for $1,300. Will be redacted as to the necessity, and we'll
No, redacted as the reasonableness, necessity stays in.
As to the sorry, you're right. As to the reasonableness of the charges, just the necessity. So whether it's $50 a block, or whether I get 9 or I get 23, whether I get all of the electrical stems or none of them, or whether I get the exercises, or all that still comes into play. It's just
Correct.
Right.
All right, guys, go ahead and put a Rule 11 in as to that, Mr. Leegee, and glad you guys worked it out, and you guys are excused. Thank you so much.
Thank you.
Thank you, Your Honor.
Okay, I think we have a scheduling conference where one of the attorneys was late. This is Thompson v. Walton, or both sides here on that?
Yes, sir. I'm present for the plaintiff.
Yes, Your
Okay.
Honor.
All right, when do you guys want to set this for trial?
I was listening to you give the other counsel dates, Your Honor. So we're into 2023. Is that correct?
Let's see, how old is this case? Yeah, 2020, you could do early 2023.
Counsel, how is February?
That sounds good with me.
Okay,
Okay.
Judge.
So let me get you some dates in February. We do have a couple dates in 23 that we have special settings, so I don't want to set them then, but let me see. You wanted February 2023, February 7th, February 14th, that's a year from today, February 21st or February 28th. Any of those are available. Which one do you want?
Counsel, how is the 21st or 28th?
I'm agreeable with that.
Okay.
Which one do you want?
The 21st.
21st. And who do you want to agree to as a mediator?
I don't have that with me. I don't have a mediator at the moment.
What kind of case is this?
It's a motor vehicle accident, Your Honor.
So Ken Rubenstein, King Pfeiffer, Jim Jordan, Mike McCullough, Mark Gilbert. Who do you guys like?
Is Mike McCullough okay, counsel?
Sure. I'm okay with that. Yes, sir.
All right. So Mike McCullough. All right. So go ahead and get us, and then whatever else you want to agree to, Rhonda, go ahead and set this for trial on February 21st, 2023, and appoint Mike McCullough as the agreed mediator. Anything else we need to chat about, guys?
Your Honor, would it also be the 30 days before with the dispositive hearings as well?
Yeah, if you guys could include in the agreed scheduling order that all dispositive motions would be heard at least 30 days prior to trial.
Okay, and pretrial will be handled closer to.
We'll figure it out on the day of trial. I mean, this is a car wreck, so we usually do those on the day of trial, but we're not going to decide that for quite some time.
Okay, sorry, Your Honor, I'm new, so that's why I was asking.
That's okay, no problem.
Thank you.
Anything else?
Nothing further from the defense.
Nothing further from me as well.
All right, great, guys. Thank you so much. You guys be safe.
Thanks,
Thank you,
Judge.
Your
May
Honor.
we be excused?
You may. All right, we have a couple other folks here. Mr. White, Miss Cannon, what are you here for, guys?
Hello, Your Honor. I'm here for plaintiff's motion to quash, defense set it for hearing.
I don't have that.
For Tammy Bridges, it's at 10:45.
That's been canceled, it looks like. Are you the movant or the respondent?
The respondent.
You may want to call the other side. They, according to this, it said it was canceled.
All right. Thank you, Your Honor.
But what I would do is call, if did they not tell you it was canceled?
They did not.
You might want to call them and just confirm. If it isn't canceled, you're free to sign back on.
Okay.
Okay.
Should I log off? And
Or
then
you can
call
just,
them?
you can, whatever you want to do, you can mute
Okay.
and turn off your camera and just call them and say, hey, is this canceled? Why didn't you tell me? But apologize for any inconvenience.
Okay. All right. Thank you.
Thank you. And Mr. White, you're here for the 11 o'clock, is that right?
I am, Your Honor.
You might want to call opposing counsel. We can start now if you want, or we can wait. I'm okay either way.
Yeah, let me call opposing counsel and see if there's something going on.